A man was injured in a road accident. He suffered a traumatic brain injury and had no memory of what happened. The CCTV footage that could explain the accident existed. He asked for it. He was refused. Then the footage was overwritten. The regulator later found no breach of the access obligation. This documentary asks a narrow question. When a person lawfully asks for their own data, who is responsible for making sure that data is still there when the law is applied? On 13 April 2024, a motorcyclist was injured on Cairnhill Road after a taxi cut into his lane. The impact caused a traumatic brain injury and bleeding around the brain. He lost his memory of the accident and the period around it. The footage was not just evidence for an insurance claim, it was the only record of an event he could not remember. Security staff at both condominiums had identified the relevant footage shortly after the accident. It was findable. It showed the area. It was still within the retention period. The requester first asked verbally, then followed up in writing. The responses were refusals. One side cited broad privacy concerns and later said there was no footage. The other said access could only be given if the police directed the MCST to disclose it. The concern raised by the complainant is simple. These were not, on their face, the statutory refusal grounds listed in Section 21 or the 5th Schedule of the PDPA. The timing matters. The accident was on 13 April. Requests were made on 17 April and 25 April. The footage was overwritten on 30 April. The complaint to PDPC was filed on 4 May. More than a year later, on 19 May 2025, 2 decisions were issued. By then, the footage was long gone. Parliament has been told that under the PDPA, organisations typically include measures to preserve requested personal data while an access request is being processed. It has also been told there are safeguards for lawful and valid requests, including retention requirements where a denied request may be reviewed. But in this case, the footage was deleted during the process, and PDPC found no breach of the access right. PDPC's handling of the complaints is a central part of the grievance. The complainant says PDPC did not substantively address the point that the condominiums had refused access using reasons not found in Section 21 or the 5th Schedule. Instead, the matter was dismissed or redirected using reasoning that was not the reasoning originally given by the MCSTs or their managing agents. The investigation appears to have moved only months later, after repeated MP appeals and escalation through oversight channels. By then, the footage had already been overwritten, and the original refusal reasons had either been abandoned, contradicted, or shown to be outside the statutory framework. The grievance also raises a concern about explanation. When the complainant relied on PDPC's own published guidance, PDPC responded that the guidance was not determinative and that the PDPA prevailed. But the complainant says PDPC did not identify the specific inconsistency, the operative PDPA provision, or how the guideline conflicted with the statute. After further questions, PDPC declined to comment further. The 2 PDPC outcomes should be kept distinct. In one, the issue turned on whether the CCTV image amounted to personal data. In the other, PDPC accepted that the footage was overwritten before a formal refusal and found no breach of the access obligation while identifying accountability failures. The grievance is not that every issue is the same, it is that both paths led away from access. The central policy concern is the gap between a live access request and the point at which preservation is legally recognized or enforced. If footage can be erased during that window, then the right to access personal data may exist on paper but fail in practice. If that is a loophole, Parliament may need to close it. If it is not a loophole, then the question is why the access right was not enforced here. A second issue is identifiability. The complainant argues that personal data should not depend only on whether a face or license plate is clear. Context can identify a person too. If security staff could locate the footage using the information provided, then the question is whether the combination of image and context should have been treated as personal data. The site also raises a broader pattern. In the compiled public enforcement register, across hundreds of published enforcement actions, the access obligation appears to have produced no breach findings. That does not by itself decide this case, but it does make the question larger than one requester. The proposed reform questions are practical. When must CCTV be preserved after an access request? Should identifiability include available context, not only image clarity? Must organizations state and test the actual statutory ground for refusing access? And where the regulator's own conduct is questioned, what independent route exists for review? The footage is gone, but the question it raises remains. A right of access is meaningful only if the data can still be accessed when the law is finally applied.